everyone. My name is Susan Settenbrino, and I'm here to talk about judicial bias and the political process. At the end of this talk, I want you to tell me, do you think that we have a system of justice or a system for just us? And I have to start off with, Joe likes attorney jokes, so just tell me, I'm sure you all heard this. What's the difference between a good lawyer and a great lawyer? A good lawyer knows the law. What is a great lawyer? Who does a great lawyer know? Okay, very good. There's my talk. Let me go. In order to help you to decide, I'm going to take you through a tour of the court system, of our court system. And we're going to discuss judicial independence, because judicial independence is key. If we do not have judicial independence, we cannot have a just court system. It's impossible. And we're going to look at the system we have, the appointments and the elections. We're going to look at the potential consequences of a political judiciary. And we're going to look at some suggested necessary reforms. So let's take a look at judicial independence. Very important. Judicial independence does not mean that we cannot criticize the judiciary. Sandra Day O'Connor has recognized it is good for us to have constructive criticism over the judiciary. That's what brings about true reform. The court's raison d'etre, its reason for being, as Sandra Day O'Connor has recognized, is that it's the one safe place where every citizen can receive a fair hearing. Have you felt that? Okay, well, that is what it's there for. The courts we created for all of you to get a fair hearing, to be heard. So when judicial independence is being advanced, it is ensuring that the rule of law is being upheld. It is ensuring that the separation of powers are maintained. It is guaranteeing a more fair and impartial process to all of us. What does this mean? This means that judges must be independent from both the state and the private sector. Independence is essential to prevent politicians or other third parties, any third parties, from using the court system in a political manner. So we ask ourselves, when is the judicial process deemed corrupted? Well, as Professor Susan Rose Ackerman has stated, it's when judges are motivated to ingratiate themselves with an authority with influence over their careers. Independence implies that judges' careers do not depend on pleasing those with political and/or economic power or anyone. The judges cannot be independent if they have to please anyone. Do our judges need to please their supervisors? No? Who says no? How do you know that? They don't. Do you think that our judges may need to please an administrative judge or an appellate judge or somebody ahead of them, higher up, to advance their careers? Do you think not? You think they shouldn't, but do you think they may? Do our judges need to please political or economic powers that be? Anyone?
Why would someone spend $5 million to get elected as a judge?
You were reading my speech. Come on, this is unbelievable. He asked me for my slides, and look what he does. Okay, so do our judges need to please third parties?
Of course, because how else are they going to get reelected?
Oh my God, these guys, they just know the answers. Come on, elected judges, read it. They need to please other parties to raise funds, right? Appointed judges, they need to please the politicians and their supporters. That's our system. The public, us, the judges don't need to please us because there's no incentive. The public generally votes for the party, not the candidate. We need to understand common sense. What's motivating the law firms, the special interest groups, and the businesses to donate so much money and time to judicial campaigns? Are they just generous people? What do they want? Well, as Sue Bell Cobb has recognized, she has asked this question: why do campaign donors give? In all other races for public office, contributors would say that they give to campaigns to ensure that candidates are elected who will represent their interests and give them access to the public official when issues arise. So are the attorneys and the law firms, the special interests, and the business giving to judicial campaigns or to politicians to appoint judges to get access to the judges? It's a question. Are they giving to get special treatment in the court, or are they just giving to give? You let me know. I want to hear from you. Well, let's take a look at the appointment and elections process and see if we can figure this out. Okay, appointments. The U.S. is the only nation that elects many of its judges. How's it working? Even when our elected officials appoint judges, they do so without any recourse or accountability. Guys, before I go to the next slide, what's the most important aspect of our government? Anybody? What's the most important aspect that we have that keeps us confident? What? Yes, you are brilliant. Checks and balances. So this is the most important aspect we can have. 3 separate functioning independent branches of government to act as checks and balances on one another. But in a politicized court system, these 3 branches are no longer independent. They are beholden to the political machine. What does that mean? That means the machine where attorneys and where special interest groups and where businesses, that they are funding this machine to ensure their candidates are in office. The governors, the attorney generals, the DAs, the assemblymen, the judges, they're all part of the same machine. So do you think there's any oversight or accountability in that machine? Are there any separations of powers? Are they all part of one unit, advancing careers? Tell me, what do you think? Okay, so now lawyers, businesses, and special interest groups are the primary contributors. They provide large sums of money. They may host extravagant fundraisers just to get these governors into office. The governors, they owe their careers to these contributors, and they will turn around when they get into office and they will appoint the most powerful judges. They will appoint lower level judges, but they will appoint the most powerful judges. And these contributors, the lawyers, the special interest groups, and the businesses may very well come before these judges on multi-million and even billion-dollar cases, okay? So if these appointed judges, that if they put judges in the office and the judges abuse their power, do you think they have any responsibility? They don't. Nobody goes back to Governor Christie and says, how can you put this judge in the office? The judge can abuse his power, can engage in criminal activity, and none of these governors will be responsible for the choices they made and who they put on the bench. So, unfortunately, the only people who suffer is the public. So let's take a look at the election process. If elected to be judge, I promise to faithfully pander to you and to find legally coherent reasons to do what you want in the following cases. This year, a prominent bar association published a report actually advising attorneys to get involved in the political process of electing judges. It's quite incredible. The Bar Association advised the attorneys, do some of the following. Become a delegate to their party's judicial convention. Collect signatures for a judicial candidate. Donate funds to support judicial candidates. I'm quoting, by the way. Comment on a judicial candidate when a screening panel calls. Join a community group involved in the process of selecting judges. Apply to the governor, the mayor, or county leader to be appointed to the screening committee. Join a bar association judicial committee. The Bar Association admitted that the attorney must become known to the people who appoint judicial panels, that most screening panels are active members of the bar or community groups. And this is crucial, that judicial elections are primarily determined de facto at the nomination stage. What does that mean? That means that the screening panel that these political attorneys are serving on, they're going to choose the judges that they may appear before because it's happening de facto at the nomination stage. And the election, well, that's just a formality, okay? So this is obviously a very concerning situation because in my opinion, and I believe Divorce Corp has the same opinion based on their documentary, that it's these type of collusive, behind-the-scenes type of relationships that are destroying judicial independence and creating a system of just us rather than justice. These political attorneys can get appointed to all sorts of funded programs, such as the fee dispute program, I'll discuss a little bit later, and say the law guardian program, you know, the children's attorneys. Actually, there was a case where a judge in Staten Island was outed for appointing law guardians to these cases, and all of the law guardians that she appointed contributed to her campaign, 100%, okay? Do you think the parents knew this? Do you think that she was serving the interests of these children? And do you think that those law guardians are going to be concerned about advocating zealously for their clients or about pleasing this judge for the next appointment? What do you guys think? You know, these political attorneys, they may enjoy lucrative practices in front of these political judges for years. These judges then may retire and go into these political law firms, okay? So it's a cycle here. And, you know, in New Jersey, it was astonishing. On the website of certain law firms, they actually list that they have relationships with certain courts, and they list the judges. I found out what it meant to be the attorney who didn't have that relationship, and it wasn't pretty, okay? So let's move on. We all know, okay? We all know that we need to stop electing our judges, and I believe stop appointing our judges as well. We know commission report after commission report, article after article, we know it's destroying our entire court system. Okay, it's not a secret. In 1906, Roscoe Pound realized that compelling judges to become politicians has almost destroyed the traditional respect for the bench. Almost over 100 years ago. You think, you know, we've gotten there yet? In 2014, the New York City Bar stated that it has been focused on judicial election reform since its birth in 1870. We're still waiting for that meaningful reform. This week in the news, Linda Greenhouse, in decades of court watching, I have struggled, sometimes it has seemed against all odds, to maintain the belief that the Supreme Court really is a court and not just a collection of politicians in robes. This past week, I found myself struggling against the impulse to say two words: I surrender. But you guys have not surrendered. You are here, and we're going to make a difference. The cycle continues. 38 states hold judicial elections to their high courts. 31 states hold judicial elections to their intermediate appellate courts. 39 states hold judicial elections to their trial courts. Money in judicial campaigns? Well, in the multi-millions. As Joe said, spending millions of dollars for a $150,000 a year job. Partisan judicial elections are by far the most expensive. Lawyers and business interests account for at least 49% of all contributions. Public confidence. 76% of voters and 26% of state judges believe that campaign contributions influence judicial decisions. You guys are not alone. Two systems of justice. 62% of voters, including nearly 90% of African American voters, feel that there are two systems of justice. Justice versus just us. Let's take a look at some of the potential consequences of a political judiciary. Here we go. This is the chief judge. We may create a concentration of enormous power and funding in the hands of a few politically entrenched, or at least very vulnerable individuals. To become a chief judge, all you need to do is get appointed by the governor. He may hardly have practiced as a lawyer, hardly have been a judge, yet he can be appointed chief judge of the entire court system. And he can be placed in a position where he oversees a budget of billions of dollars. The chief judge enjoys extraordinary power without any interference, regardless of how dysfunctional or even dangerous the court system under his administration may be. Now, no matter how wonderful you think this man is, no one deserves this much power and this much control over the court system and its multi-billion-dollar funding. Nobody. This creates a political court system that becomes an impenetrable vacuum of enormous power and funding. It's like that song says, you can check in anytime you like, but you may never leave because you are stuck within this vacuum. And this chief judge, the governor puts the chief judge in. He could put the Court of Appeals judge in. The presiding judge, governor could put him in. The chief judge can appoint the administrative judge, a few, and the judges underneath them. And then you have the trial courts. And so and then you have the inspector general. And you can have the Commission on Judicial Conduct. You have a problem with the judge? Go to the Commission on Judicial Conduct. Don't worry, you'll be heard. You have a problem with integrity in the court? Go to the inspector general. You need a law guardian? Right there. And mental health professionals here. Attorney discipline. It's all right here. One-stop shop. No problem. Okay? So, very important. Susan Ackerman has detailed how you can use the court system as a political gender and even a criminal enterprise by creating an opaque, overly bureaucratic court system with an incentive for payoffs to cut through the red tapes, by creating bribes to staff, such as clerks and trial judges, can speed up or slow down cases. If pay and working conditions are poor, and they always seem to be, judges and their staff may be relatively easy to corrupt. If top judges are corrupt or politically dependent, they can run a punishment and reward system by transferring or promoting appellate or trial judges. Judges can manipulate assignments of cases to the judges willing to rule in favor of select attorneys. I was on the case for a year. The case was concluding, it was over, one day left of trial. The judge was fair, was acting fair. We found evidence of fraud on the other side. Suddenly I get a phone call transferring the case to a judge with a documented history of misconduct. Everything gets turned upside down. Trial judges can easily manipulate trial procedures in favor of certain attorneys and their clients to ensure certain outcomes. The courts can be used to protect misconduct and even crimes. The disciplinary and the judicial ethics committees can protect attorneys and judges. Fee dispute committees can protect fraudulent billings. Judges can ensure a lack of oversight and accountability. Judicial budgets can be skimmed or redirected. In addition, if the judicial budget is being used to promote offices that target and protect, that's unlawful. The consequences of a political judiciary. Well, the disciplinary committee can open up false investigations against an attorney. They don't have to have any merit. They just keep it open. They ruin the attorney's career and finances. You can have political attorneys serving on a fee dispute committee and make fraudulent fee disputes against an attorney. And they can issue fraudulent awards and at the same time protect their own fees. It's quite incredible. And they get immunity. So, false orders and judgments. This is one of the worst things that we can experience in a courthouse. Every order is a powerful blank canvas. False orders and judgments can easily be created and continue for years. By placing politicians on the bench, decisions become unpredictable and the outcomes can be chaotic and, I believe, dangerous. So what is a false order? When a judge creates rulings that knowingly fabricate, obliterate, and distort the facts and/or controlling law of a case. As Monroe Friedman has said, Frankly, I've had more than enough of judicial opinions that bear no relationship whatsoever to the cases that have been filed and argued before the judges. I'm talking about judicial opinions that falsify the facts of the cases that have been argued, judicial opinions that make disingenuous use or omission of material authorities, judicial opinions that cover up these things with no publication and no citation rules. What's the foundation of false order is intellectual dishonesty. Professor Anthony D'Amato. What kind of a judiciary system has this society produced where judges can misstate the facts of a case and then proceed to apply the law to those fictitious facts? Can anybody be safe in this court if this practice is allowed to continue? If judges can listen to the evidence and then tell a contrary story, what remains of justice? The vaunted security that we have in a free country and a just legal system turns to quicksand. False orders can protect criminal misconduct, even in the face of overwhelming verifiable evidence, even in the face of admissions, even in the face of a dead body in the trunk. Okay? False orders can erase evidence, events, and facts. False orders can create new facts, new evidence, and even transform people into monsters. False orders can extort funds, creating sudden, unwarranted wealth and/or indebtedness. False orders can destroy children, families, the elderly, individuals, and businesses. False orders take on a life of their own. False orders can put innocent people in jail. Well, reforms are necessary, but what we don't need any more political committees, and we don't need any more commission reports or interim rules. What we know that we must stop judicial appointments and elections. We know that for the most part, the judicial ethics committees are ineffective. The attorney disciplinary committees are ineffective. The appellate process, for the most part, futile. The federal courts, for the most part, will not intervene. The legislative and executive branches are ineffective. What we need, as Professor Susan Rose Ackerman has pointed out, courts must publicize their operation and decision process. Judges must disclose their assets and conflicts of interest. Outsiders like us must be able to find out what is happening in those courthouses. A free media with access to judicial proceedings and documents, along with an active civil society to publicize lapses and work for reform. The media isn't doing its job. Many of them endorse the political judges, and they don't report what they should be reporting. There was a judge, he published a decision of interest in a prominent newspaper that was false. But they published it. I called the editor. I said, I can show you. It's verifiably false. Don't enable this misconduct. They didn't listen. We need accountability. We don't need immunity. In earliest English law, judicial immunity was not an option. Personal actions could be brought against judges. The judges faced serious consequences for creating false or malicious judgments and for acting outside their authority. We need to create a clear decentralization of power and funding. We need to establish an apolitical body of oversight. We need to ensure that judges are well-versed in the laws that they preside over. We need to choose judges based solely on their merits, and we need to ensure juries for all. It's not perfect, and they can be impacted by a biased judge, but it's still better than not having a jury trial. And they should be present with custody, finances, and disciplinary actions as well. We need video cameras in the courtroom with available recordings so that we can attain them. We need a database to establish and track patterns of bias, collusion. We need complaints against judges to be transparent. We need to know the disciplinary process and how it's being utilized. We need to see the history. There's been many judges, I'm sure, I understand, that have been transferred. We don't know what's going on behind the scenes and what complaints are made. Very important, we know who our judges are. We need a code of judicial conduct to be made enforceable. So, this question's for you. Is this a system of justice or a system that promotes just us? What's the verdict? I know the answer too. That's why I wrote the Unchecked Power Guide. Thank you.